Okay, good afternoon, everyone. This afternoon, after building through a digital governance series in which we've looked at lots of aspects of data protection and automation of public law decision making, we're probably going to have a final seminar in the series now from Christopher Knight that builds a lot of these elements together to look at how public law is changing in the UK and how data protection, which was once seen as being quite a niche area of practice in UK public law, is becoming more and more common as an element of illegality within judicial review, and some of the challenges that are being raised within that head and some of the problems with bringing those challenges. Christopher has very kindly agreed to speak for around 40 minutes, although if we're in full flow, things can run on longer than that. And then we'll have some time for questioning before the end, and we're hoping to wrap up everything for 5 p.m. The session is being recorded, so if you know anyone who was hoping to attend who isn't able to make it, then this session should be live on Newcastle's website in the coming days. But without further ado, I will welcome Christopher Knight and thank him for coming along and turn over the floor to him for this afternoon's seminar.
Thank you very much, Colin, and thank you very much to you and to everyone connected with the Data Governance series at Newcastle University for inviting me to speak and to follow in the virtual footsteps of some excellent speakers in this series. I feel very much like the slightly underwhelming instalment in comparison, the sort of Detective Superintendent Ian Buckles of this lecture series, if you like. So this talk is on the interaction and interplay between data protection law and public law. Now, public law has long been an easy subject to get students and indeed non-lawyers interested in. The boundaries between state and citizen, pools of law versus politics, etc. Data protection law, as Colin adverted to, is not, it is fair to say, generally thought of as being at the sexier end of the legal spectrum. Indeed, most law students will go through their studies and many legal practitioners will manage to go through their careers without really ever having to understand any aspect of data protection law. And yet people do now sort of know what the GDPR is. I even did a pub quiz a couple of years ago to which the answer to one of the questions was the GDPR, an outcome which is unthinkable, not only a short period before then. And that increased awareness of the existence of data protection law extends to lawyers and particularly public lawyers. And there's a real noticeable uptick in public lawyers looking to use data protection law as a way to achieve results the ordinary heads of judicial review, illegality, rationality, procedural fairness, less easily enable. But that, it seems to me, also poses some problems for both data protection law and public law. And I want to discuss, that's what I want to discuss today and sound some notes of caution about the use of data protection law in this area. And I think the best way to do that is by examining a few example cases and contexts where public law and data protection law have rubbed up alongside one another. I'm not going to focus in this talk on cases in which data protection law itself has been subjected to public law challenge. So, for example, the Open Rights Group and 3 Million challenge to the inclusion of the immigration exemption within the Data Protection Act 2018, in which judgment from the Court of Appeal is awaited. And nor am I going to look at the extremely unsatisfactory line of case law from the Luxembourg court applying data protection and electronic privacy law to retention of communications data for the purposes of national security and prevention of crime. There are some big, difficult issues that arise out of there, both on scope of EU law and proper constitutional boundaries between the respective legal systems, even without looking at whether the decisions are right on their face. I'm going to focus on cases challenging the decision-making of a public authority, relying as a ground of challenge on breach of data protection law or data protection law concepts. And a really interesting way into this topic is, I think, the summer 2020 examination results debacle. And I think it's probably fair and generally accepted to use the term debacle in connection with that results round. Now, during, as all of you will no doubt remember, during the height of the pandemic, the Examinations and Qualifications Regulator, Ofqual, took the decision that with the cancellation of GCSE and A-level examinations, and I'm doing a lot of simplifying in this context, awarding organisations, the exam boards, should award grades by reference to a variety of data points on students and on the schools that they attended, including the school's past history of converting things like mock results and winter examinations into the final summer grades, in order to try and avoid the risk of grade inflation, which would occur or potentially occur if grades were awarded solely on the basis of teacher predictions. And indeed, Ofqual ran a public consultation on the approach it was going to adopt. And similarly, in parallel, although not in discussion with Ofqual, the private sector company which runs the International Baccalaureate qualification, which is not regulated by Ofqual, is based overseas, adopted a very similar approach, not exactly the same, but very similar for present purposes. And as everyone who is not living under a rock knows, when the A-level grades were announced, there was a swift public backlash, with parents and students feeling that in some cases they were receiving grades below or well below what they expected. And blame was particularly attributed to the use of Ofqual's algorithm, well, technically the awarding organisation's algorithm, but Ofqual's authorisation of the use of algorithms, and in particular its use of historic results information as a data point in setting that algorithm. And it's in the public domain that pre-action correspondence was sent to Ofqual and to the Department for Education, proposing to bring a judicial review to challenge those A-level grades and the approach used to set them. And amongst the grounds were allegations that Ofqual had failed to comply with the GDPR. Ultimately, and before the same approach was taken for the GCSE results, DfE and Ofqual announced a fundamental change of position, and accordingly the JR never really got off the ground. But interestingly, and this is also public knowledge, the organisation which runs the IB took quite a bit longer to change its approach, and in the meantime it received preliminary findings from the Norwegian Data Protection Authority that its processing of data to issue grades using a similar sort of algorithm breached the GDPR. And the Information Commissioner here has announced that it's commenced an investigation into Ofqual's approach for similar reasons and in a similar way. Now, let's leave aside for the moment the particular protections in the GDPR against automated decision-making. You've had seminars on that topic. A more interesting strand for present purposes of the Norwegian DPA's reasoning was that the approach taken by the International Baccalaureate in the use of data in setting the algorithm, which did not directly concern the candidate, was not fair processing in accordance with Article 5.1a. And quite a lot of domestic commentary here about Ofqual and its approach was making very similar arguments, encouraging the ICO to at least investigate the same point. Was the use of an algorithm that takes into account and uses as a data point school-based data, not linked to the candidate themselves, fair processing of personal data within the meaning of what we used to call the first data protection principle? But that seems to me to raise really difficult issues. Now, one can well see why, as a matter of ordinary language, students felt that their results were, in inverted commas, unfair. But unfairness per se is not a ground of judicial review. The Supreme Court confirmed that to us in Gallagher and the Competition and Markets Authority. It has to be so unfair that the decision is irrational. And it's actually potentially quite hard to say that the use of a series of data points to try and avoid grade inflation, which is after all a statutory duty that Ofqual has, developed after public consultation, was necessarily irrational. So can data protection law really be used to fill that gap? And that seems to me, the suggestion that it can, seems to me to be seriously problematic, however much sympathy one might feel for affected students. The concept of fairness in data protection law must concern the processing of the personal data concerned. There are real difficulties of principle if that is transmogrified into a freestanding duty to act fairly, whatever that might mean, in every context in which data is processed by a public body. Mr. Justice Cranston explained there's very little judicial consideration of the fairness principle, either in the GDPR or its predecessor in the DPA 98. But Mr. Justice Cranston had to look at it in the AB and a Chief Constable case, which was all about references for a senior police officer and the withdrawal of a reference and a second reference which made reference to disciplinary proceedings. That's thunder behind me. I'm not looking forward to the walk home. Mr. Justice Cranston explained that the fairness principle in the GDPR and the DPA must be on the immediate decision to process the personal data. And he was reluctant to view fairness in the sort of wider context of the relationship between the officer and the police force. Asking whether the standardization model Ofqual used or the IB used is a fair way to assess student attainment in the context of the pandemic, it risks confusing questions of data protection with questions of education and qualification regulation. And if one considers the point in constitutional terms, or public law terms, on what basis can anyone suggest that the draftsperson of the GDPR or the draftsperson of the DPA 98 before it intended that the Norwegian data protection regulator or the information commissioner in the UK has the ability and the power to exercise authoritative control over the performance of an examinations body or indeed an examinations regulator? To put the point bluntly, what does the ICO know about examination regulation? That's not its job. Who authorized the data protection regulator to tell examinations regulators what examinations model it should adopt in compliance with its statutory duties? A court wouldn't do so on a judicial review. Why do we think the GDPR would have afforded that entitlement to the Data Protection Authority, or indeed to an individual data subject by way of challenge? On what constitutional or legal basis does or should the GDPR enable the courts to sit in judgment on the merits of public law decision-making in a manner which, even under the Human Rights Act, they are at pains to emphasise that they don't do? And that the problem, of course, I think comes from the use of very broad and unfocused concepts such as fairness and, in various respects, necessity and appropriateness and various other sorts of language that one sees in different places within the legal framework of both the GDPR and the Law Enforcement Directive and the Data Protection Act 2018. In the context of a legal framework which applies to almost every context of public authority decision-making imaginable. It is important for data protection lawyers, seems to me, to recognise that data protection law is a critically important protection and a control, but it cannot be a panacea for all the things done that one does not like or approve of. Because if fairness is stretched to mean anything, then ultimately it really means nothing at all. And to move from that sort of general concern arising out of that public debate, it's useful to consider how similar sorts of points have played out in litigation. Now, there isn't a huge amount of this, but there are a few cases in which the courts have been invited to take a similar sort of approach or engage in similar sorts of concerns. So a similar issue, slightly similar issue, arose in the El Ghazouli litigation. Part of that litigation is very well known. The second part of it is less well known. It's the second part of it that's more interesting for present purposes. The context of the El Ghazouli litigation was that Mrs. El Ghazouli is the mother of one of the so-called ISIS beetles. And she originally challenged the decision of the then Home Secretary, Sajid Javid, to provide evidence held by the UK authorities on the ISIS beetles and their undoubtedly appalling crimes, alleged crimes, but fairly clearly crimes, to the US authorities, who had requested it under mutual legal assistance treaties. in order that the US, who held them in custody in Iraq, could try them in criminal proceedings in the US courts. The original judicial review was on the basis that the decision to transfer that evidence, which was an international transfer of personal data governed by Part 3 of the Data Protection Act 2018, was impermissible where the US had refused to give assurances that they would not seek the death penalty in relation to those two defendants. The Supreme Court found in that first JR a breach of the data protection requirements on the basis that the Home Secretary had simply not considered the Data Protection Act at all when making the decision. And I'm going to come back to that in a moment. But after the Supreme Court judgment, there was a Part 2. The US did subsequently give death penalty assurances, and the Home Secretary retook her decision with careful and very thorough regard to the international transfer provisions and the permissible gateways. And I should say I acted for the Home Secretary on the second judicial review, but wasn't involved with the first. Her decision to transfer the evidence was challenged by Mrs. El-Ghazouli again. This time, the judicial review focused on whether it was necessary, and that language is used in various places in the international transfer provisions in Part 3, whether it was necessary to make the transfer of the personal data. It was said by the claimant in particular that because the CPS had recently decided that there was sufficient evidence to charge the ISIS beetles in the UK, it was not necessary for the transfer of data to be made because it was not necessary for them to be prosecuted in the US. And the Divisional Court's judgment, which has generally seen rather less coverage than the Supreme Court's, the Divisional Court's judgment firmly rejected that approach. It explained that the question of necessity must be assessed by reference to the purpose of the transfer. And the purpose of the transfer was prosecution in the US. It was not to be assessed by reference to some other purpose that the claimant might look at. And there's a close analogy there with what one sees in the case law, both under human rights law, but particularly under discrimination law, where the courts are used to saying claimants cannot substitute the legitimate aim that the decision maker has relied upon. The proportionality of the decision has to be assessed against the decision maker's legitimate aim. It's not for the claimant to come along and reframe it so as to then win the proportionality challenge. And on the facts, the US had made it clear that it couldn't prosecute without the information, but that it would prosecute with the information. And in essence, what the Divisional Court was doing was rejecting an analysis which sought to import into a specific data protection law test a much wider array of public law concepts, so as, in substance, to review the Home Secretary's decision on its merits by reference not just to rationality, but to relevant considerations in particular, and a variety of other potential ways of putting the point. Given that had the challenge succeeded on that point, there was a real risk that Part 3 of the DPA would have realistically gutted the mutual legal assistance framework without any apparent intent on the part of the Law Enforcement Directive or Parliament to do so. It seems to me that the Divisional Court was right to take the analytically rigorous approach that it did, and that I think gives some indication of how public law and data protection can work together, but the respective roles should not be confused. In contrast, the Supreme Court's decision underlines the value that data protection law can bring in a public law context. The common law argument that ministers couldn't lawfully assist a foreign death penalty prosecution failed in the Supreme Court by a majority on the basis that the common law had not yet developed that far. But there was a separate freestanding data protection challenge that succeeded, and that success was significant. The core of the Supreme Court's reasoning in this respect involved effectively basic public law principles. The Home Secretary was required to consider a set of mandatory statutory tests at the time of the decision contemporaneously and with due consideration. And it was absolutely clear and not disputed that he did not in fact do so. He was not aware that Part 3 of the DPA would apply to this decision. And in the absence of death penalty assurances, the court couldn't see how those tests could have been met. Now, there are certainly elements of the Supreme Court's reasoning on that final aspect, which engage precisely the issue of concern that I'm talking about, because there are some strands which come quite close to saying, although I'm not sure that it actually does say in terms, Lady Hale, I think, comes closest, that it could never be lawful for a transfer to be made under Part 3 in a context where there weren't death penalty assurances, because to do so would be inconsistent with EU law principles underlying Part 3, and in particular derived from the Law Enforcement Directive and the Charter. And that does seem to me to be problematic and risk importing a value system into data protection law concepts which goes beyond the proper scope of those concepts and the particular focused drafting of the transfer provisions. But the more procedural aspects of the decision in El Ghazouli on contemporaneous consideration seem to me to be perfectly normal, perfectly logical, perfectly proper controls on public authority decision making, requiring ministers and decision makers to have regard to the things that they are required by the law to have regard to. And those more procedural aspects seem to me also to be reflected, at least to some extent, in the Bridges facial recognition software appeal decision from the Court of Appeal. There, the Court of Appeal focused on Article 8 of the Convention to address the gap in the legal framework that it considered applied to the use of automated legal recognition, automated facial recognition, such that the scheme was not in accordance with law, although I think it's fair to say the judgment as a whole suggests that it wouldn't take a huge amount of effort to render the scheme in accordance with law or with enough work. To be fair, the argument did not, and certainly the court did not, seek to address that substantive question through the GDPR or through Part 3 of the DPA. There were DPA arguments, and to the extent that the Court of Appeal found that the data protection impact assessment done by the police fell short of the standards that the law required, it was because it had not reflected the court's own ruling on the lack of convention compliance and the in accordance with law test. The DPIA, the Data Protection Impact Assessment, was seen as something which ought to reflect concerns arising from rights more generally, but was also clearly analysed by both the Divisional Court and the Court of Appeal as being something very similar to, not exactly the same as, but very similar to, an equality impact assessment under the Public Sector Equality Duty in Section 149 of the Equality Act, something that flags the issues but doesn't determine the substantive outcome of the decision making. And the need to comply with that duty, the DPIA duty, was important, but data protection wasn't used as the vehicle to drive the analysis or indeed the attack on automated facial recognition. And there is, I think, a tendency on the part of data protection specialists to see the GDPR and the DPA as the portal through which all problems should be analysed. And similarly, there can be a lack of awareness on the part of public lawyers of the additional legal duties and controls which data protection law rightly imposes on public authority controllers. And some sort of middle way, I think, is required, which recognises the vagaries of many, the untested vagaries of many of the data protection concepts. And in the particular context of its application to public authority controllers, a constitutional need to ensure that those concepts are not used to create a merits jurisdiction for the courts, or indeed the regulator, to intrude into decision making in which the courts have no or little institutional or constitutional expertise. A helpful guide to the future with which to sort of work towards the end point of this talk before questions, is I think the decision of the Court of Appeal in M and the Chief Constable of Sussex Police. Now, that case concerned data sharing by the police with the local business crime reduction partnership. And what it involved was the police providing local businesses through that partnership with some identifying information about individuals with a particular history of crime and antisocial behaviour. And a significant question in the legal challenge brought on behalf of one of those individuals, who was a young person who had been who was subject to various safeguarding concerns as well as antisocial behaviour orders. A significant question in the challenge was the extent to which the police had in place in its information sharing agreements appropriate organisational and technical measures for safeguarding against unlawful processing within the meaning of Part 3 of the DPA, similar language in the GDPR. And the Court of Appeal emphasised in the judgment of Lady Justice Andrews that the appropriateness of safeguards is a holistic concept which must be assessed in the round by reference to all of the information before the court. And she particularly then went on to emphasise that data protection law did not dictate any particular granular measure or particular approach. And the legal standard of appropriateness did not permit the court to micromanage how the controller complies with the requirement. Now, that sounds to me very much like the application of a rationality standard or something very much like it. And arguably, given the general points of principle that I've been raising, rightly so. The GDPR and the DPA impose important protections, but the courts do not traditionally wish to conduct some sort of detailed due diligence exercise on every aspect of the extensive array of very onerous obligations, potentially very onerous obligations imposed by that legislative framework. When legislation uses very broad concepts like fairness, like appropriateness, like potentially in some circumstances necessity, how those concepts apply in a particular context necessarily requires an exercise by the controller of judgment. And controllers have to be given some room for the exercise of that judgment, just as public authorities are given room for the exercise of judgment in ordinary public law decision making and judicial review contexts. And so it seems to me that although some of the discussion and the debate, particularly in the data protection sector, privacy sector, and commentators and those interested in the area, it can be quite hard line, and the regulators can appear to be taking a quite hard line approach that fails to recognise or risks failing to recognise the importance of maintaining, considering whether or not what the proper role of regulators and courts are under the GDPR. There are real trends in the case law, at least, particularly so far under the law in the law enforcement context under Part 3, which recognise the need to avoid imbuing data protection law with some sort of mythical qualities of the philosopher's stone. That data protection law is an additional tool by which public authorities can be held to account to make sure they are thinking about the right things when they are taking decisions in the form of data protection impact assessments, to make sure they are looking at the legal tests that govern the decisions they have to take in the form of making sure, see El Ghazali and the failure to have contemporaneous regard to the legal standards that are applicable. But that it is not necessarily a route by which the courts acquire a jurisdiction to stand in the shoes of the controller and retake the decisions, complex decisions, difficult balancing decisions on the merits by reference to broad and unexplored concepts of such as fairness. And that seems to me that balance that is carefully being trod by the courts in El Ghazouli No. 2 and in Chief Constable of Sussex Police seems to me to reflect a proper balance in our constitutional landscape. That is not to say, and I end on this point, that I recognise that a real difficulty in raising the concerns that I have in the course of this talk is how one approaches the problem that the GDPR is not a public law only tool, and Part 3 of the Data Protection Act is not necessarily a public authority only tool, though obviously Part 3 will primarily only apply to public authorities. GDPR applies across the board, applies to public sector and private sector controllers. It would be undesirable and unattractive for the court to take a different approach to a private sector controller as opposed to a public sector controller. But I'm not sure that that is necessarily an argument for a more intrusive role on the part of the courts than the suggestions I've been making that courts need to be very wary about being drawn into the merits. The courts are no better placed to engage in the difficult balancing exercises that a private sector controller may have gone through on the substantive processing that is undergoing than they are in relation to a public authority controller. There may be fewer constitutional competence concerns, but the institutional ones may frankly be all the more weighty. And indeed, in some contexts, the courts in the data protection concept have recognised a need to allow controllers not quite a margin of appreciation, but at least something along that looks a little like that. The main example, the only real example where there's any consideration of this, it seems to me at the moment, is the DB and GMC case in the Court of Appeal on subject access requests and the proper approach to be taken where a subject access request encompasses third-party personal data, and how does the controller strike the balance between the data subject who has made the requests rights to obtain that data and the third-party data subject rights to have their data protected from disclosure to the requesting data subject. And that's a difficult exercise. Now, in some, if one were thinking of it purely through a proportionality balancing exercise under the convention, one might be able to articulate an argument that says proportionality is, on orthodox case law, a question for the court. And so the court should stand in the shoes of the controller and conduct that balance itself. That's not the approach that the Court of Appeal took in DB and the GMC. It recognised that it was a decision that is at least primarily for the controllers and then for review by the courts. It emphasised that language of review, just as a similar approach had been taken in Durant and the FSA all those years ago, when it was for a long time the only case on most areas of data protection law. And so that too is consistent with the cases, the more recent cases that I've been looking at. There is, I think, therefore, something of a theme developing in which the courts recognise, at least implicitly, the concerns that I have been talking about, and have sought to address those by a reference to an approach that does afford some measure of respect to the controller's decision making, and adopts a slightly more hands-off reviewing function as opposed to a merits appeal function, regardless of the breadth of the language of the data protection legal framework under which they have jurisdiction. And I think that's an appropriate place to pause, and we are about 40 minutes.
Well, thank you very much, Christopher, for that presentation. And hopefully everyone will take the opportunity to use the clappy hands feature on Zoom to say thank you in an appropriately 2021 fashion. I'm going to stop the recording at that point so that everyone can feel free to take part